Hi, everybody. It's attorney Ryan McKeen. I'm here with attorney Matt Eagan, and today we're here to talk about a really big case in Connecticut appellate law concerning dog bites. The case is Sen versus Songus, and we have attorney Matt Eagan on with us who won the case before the appellate court. Good morning, Matt.
Good morning, Ryan. How are you?
I'm doing well, Matt. Matt, can you explain to us dog bite law in Connecticut in general?
So in general, the general statute 22-357 imposes strict liability on the owner or keeper of a dog for for a dog bite. This case was a little bit different because it involved not the owner and the keeper of the dog, but the landlord of of the apartment building where the dog lived.
So when you mean strict liability, so it doesn't matter if the owner did anything wrong when the dog bit. It just matters that that they own the dog or they were in control of the dog and the dog bit somebody. Correct?
That's correct, with certain exceptions, such as one of them is taunting, or taunting the dog. If somebody's taunting the dog, or if somebody has sort of broken in, obviously there are certain exceptions to that. But in general, yes, the owner of a dog is liable whether they are at fault, whether they had notice of the fact that the dog might bite somebody. They're liable.
And can you tell us about what happened to Isha Sen, or what is alleged, or what is alleged to have happened with Isha Sen in this case?
Sure. So she lived on the second floor of a two family house, basically. In order to access her apartment, she had to go up a set of back stairs. The owner of the dog lived on the first floor, and so each day she would have to go by this dog. And she states that the dog was, growling, barking, exhibiting sort of vicious demeanor whenever she walked up those stairs. And one day, it burst through the door to the back porch, and it bit her. It bit her on her hand. She had to go to the hospital, and could sustained quite a bit of damage to her hand.
And was there any now there are a lot of tenants in Connecticut and a lot of dogs and a lot of landlords, and Connecticut's housing supply has a lot of 2 and 3 family houses, not dissimilar to where Miss Sen was living at the time she was bit. And can you tell us anything about the lease that Miss Sen had with her landlord, and the lease that the dog owner had with the same landlord?
Right. So her lease, the lease to both apartments in this particular building, called for no pets. Um, and one of the things that was, I think, important was that when Isha Sen discovered that there was going to be that the landlord was going to make an exception for the tenant on the first floor and allow that tenant to have a dog. She says that she asked to move out, to have to out of her lease, and was told no. But she also says that one of the attractive things about that particular apartment to her was the fact that it was going to be a pet free zone, a dog free zone. Um, but in this case, the landlord decided to make an exception to his own lease, to the lease that he had provided to both tenants.
And can you tell us a little bit about this dog and how it came to be on the property?
Right. So this dog was it was a pit bull, or a pit bull mix, um, that was adopted from one of the local humane societies, but had previously been used as a bait pit bull in dog fighting. And I'm not sure that everybody knows what a bait pit bull is, but that is essentially a dog that is is sort of tied up and prevented from defending itself, and is used to train other dogs to attack, sort of without mercy. Um, and so it's a highly traumatic and a highly, um, it's just an awful situation for that dog. Uh, um, there's not, so that was the history of that particular dog.
And how, I mean, how did was the landlord aware that the dog was there, and does that matter? Can you explain a little bit more? I know you touched on it a little bit before, but can you explain just a little bit more about how this dog sort of really comes to be here?
Right. Well, so the landlord, was aware that the dog was on the premises. The first floor tenant told the landlord that he was going to adopt the dog. Uh, the landlord made the exception to the lease to allow this. And so one of the things that a landlord has a duty to do is, and this goes back to common law. This is not a statutory law. So this has been the law, uh, going back hundreds of years, is that it's liable for, the landlord has a common law duty to protect tenants from any sort of known hazard on the property. And fairly recently, what courts have held in Connecticut is that a dog known to the landlord can be such a hazard on the common areas of the property, if the dog is known to have some kind of, is either known to have, or a landlord should have known that dog has some kind of vicious propensity.
And so Miss Sen brings her case to New Britain Superior Court. And can you explain to us what happens at the trial court before you got involved?
So before I was involved, the defense moved for summary judgment. In other words, they moved to dismiss the case, basically on the, saying there's no issue of fact here, she has no case. And their main contention was the landlord didn't know. He didn't know that the dog was vicious. He had submitted an affidavit saying, I didn't know the dog was vicious. He had appeared at a deposition and said, I didn't know the dog was vicious. In response, Isha Sen and her attorney had submitted like an affidavit saying that whenever someone approaches the apartment building, the dog would bark and growl and act in a vicious manner. And so the trial court, with this evidence in front of it, granted the motion for summary judgment, and essentially that's the end. That would have been the end of Isha Sen's case.
And so when the court grants summary judgment, an appeal was taken, and that's when you get involved. That's when you get brought on to the
Right.
case. And anytime you bring a case up on appeal, there have to be issues that are appealed. What were the issues specifically that were appealed in the Sen case?
So we had two main issues. Obviously, what we're appealing is the granting of the summary judgment. But the two issues that we had is we felt that the trial court necessarily had to make a credibility determination between the story told by the plaintiff and the story told by the landlord. And at the summary judgment phase of a proceeding, that's not permitted. At the summary judgment, in this case, the defendant moves for summary judgment. So the trial court was obligated to take the facts as asserted by the plaintiff, by Ms. Sen, as true, and determine whether, if these facts are proven, there is a case. And our argument was that the trial court did not do that. That it weighed the credibility of the two things, and made a determination in favor of the defendant. Second, one of the things that Ms. Sen tried to show was that the fact that the dog was a pit bull should have been a factor in consideration of whether the landlord had an obligation to sort of make an investigation as to whether this particular dog was vicious. And so that was those were the two basic thrusts of our appeal.
And so, what can you describe? So you write in any sort of appellate process, you file a brief, you then bring it and you argue before the appellate court. Can you talk to us a little bit about the argument that you had in this case, what the concerns of the various appellate judges were, and just shed some light on that process for us?
Right. So initially, I can tell you that, I can tell you my concerns upon taking the case, and looking at the record in the case. My concern was that in her affidavit, she had stated several things, such as, in my opinion, it is my opinion that anyone who saw this dog would, and I'm paraphrasing briefly, but anyone who saw this dog would recognize it as a vicious dog. And what I was concerned about initially is those sort of introductory, in my opinion, phrases. And I thought that the law was pretty clear, but I felt that we had to make sure that the appellate court looked past that introductory phrase to the facts that underlie her statement. So whenever the dog behaved in a vicious manner, whenever anybody approached the building, in terms of an affidavit, that's a factual statement as far as a witness witnessing something. In this case, Miss Sen witnessing people approaching the building and the way that the dog reacted. It's not an opinion. And so what we had to be certain of is that the appellate court would see that too. So that was my initial concern. In addition, anytime you're sort of arguing, look, I like dogs, right? I don't want to be the guy that's standing up there and saying, every time you see this kind of a dog, it means that the landlord has some kind of a duty. And I felt that we needed to be very clear that that was not our argument. Our argument was that consistent with Connecticut law, just like certain the horses may have pose certain dangers, certain dogs pose certain dangers, and a landlord needs to check it out. And if they check it out and they find that the dog is licking the faces of everybody that comes by, that's terrific. But that there is sort of a heightened duty. So those were, but I didn't want to appear to be up there saying all dogs are all dogs are necessarily mean or create some kind of a hazard. Fortunately, and it was very early into the oral argument when I realized the court that we had been clear and the court completely understood our argument. That our argument was a limited one and not calling for sort of a sweeping, as the trial court had said. The trial court had said, I'm not about to make a sweeping statement that anytime a landlord sees a pit bull, he's on notice. That was not our argument, and the appellate court recognized that was not our argument. Very early it was apparent.
And so what issues did the court ultimately decide, and in when they rendered their decision in favor of Miss Sen?
Right. So the majority decision is it goes along on the sort of traditional summary judgment standard lines. It says, yes, the trial court necessarily had to make a credibility determination to grant summary judgment in this case. It's not allowed to do that. You have a statement from the plaintiff saying, geez, whenever anybody approached this building, the dog acted in a vicious manner. You have a landlord saying, I never saw the dog be vicious. That's for a fact finder to resolve. That's for the jury to resolve. You can't do that. You can't resolve that at summary judgment. And that's how the appellate court, the majority decision, decided it. Judge Prescott, in a concurrence, did go into the argument regarding the specific breed of the dog, the pit bull, which many courts have throughout the nation have recognized that in one way or other or another may require a sort of heightened scrutiny among landlords. That and for instance, they are the plaintiff had actually introduced evidence that they're banned on military bases. The New York City Housing Authority bans them. And whether I'm certain that there are people who are going to say that that's unfair, but that is a recognition of the fact that unfortunately these particular dogs tend to be used in dog fighting more often than other dogs. Dog fighting, understandably, sort of alters the way a dog may react in future circumstances. And nobody's saying you can't in Connecticut, nobody's saying you can't have a pit bull. They're saying that if somebody has a pit bull, it's a factor in determining whether in what you have to do to make sure that particular dog is not vicious.
So, would the Sen case have any applicability to, say, folks who, to possibly a car accident case where a defendant says, look, I wasn't negligent. I was driving correct. I was driving properly and following the rules. And the plaintiff says, no, you weren't. Would the court engage in sort of a similar analysis if this wasn't a dog bite?
Absolutely. The majority opinion is very, very applies in a lot of circumstances. It applies in any circumstance where summary judgment is granted, or even before it's granted, trial courts should consider it. Wherever what you have is somebody making an allegation, somebody on the other side saying, no, that didn't happen. The allegation that this happened, somebody on the other side saying, no, it didn't happen. That's not an appropriate place. That's not appropriate for summary judgment at that time. It very specifically says that matters of credibility, where you're trying to determine, well, who's telling the truth here? If it comes down to who's telling the truth here, that's a matter for a fact finder, for a jury. And it's not appropriate for a court to make that determination at summary judgment. So it would apply in a car accident where that's the case. It would apply in other premises liability cases if there's a big hole on a step on the property and the landlord says, I never noticed the hole, but the landlord was, but I was there all the time. It would apply there. That's not an appropriate means to determine to decide a case on summary judgment. That's for a jury to determine.
And I think that's a really important case, because really in winning this case, Matt, you preserve the right to a jury, the constitutional right to a jury for a whole class of plaintiffs. That if the trial court's ruling had stood and other courts had followed it, would have deprived others in many, many contexts of the ability to get to a jury simply by the defendant saying, well, I'm not responsible for this in an
Right.
affidavit, which is awfully convenient. So what I'd like, so if there's a tenant out there who is bitten by a dog of another tenant after the Sen case, what rights do they have potentially against their landlord, and what things should they be looking at?
Well, what they should be looking at is, and what they should be looking at is whether the landlord should have known that allowing that tenant to keep that dog on the premises posed a risk of what happened, which is, in this case, was a dog bite, which is, of course, allowing a tenant to keep a dog does, that's the natural risk of keeping a dog, is that the dog bites somebody. And so what they can look at is ways in which the landlord should have known that this particular dog had vicious, or had a vicious demeanor, or was prone to bite somebody. It doesn't mean that nobody can have dogs, but it does mean that if the landlord is on the property and the dog's barking and growling, he doesn't get out of it by saying, I never noticed that. And so those are things. What a tenant would want to look at is, how many times did that landlord come to the property? Was the landlord there, weekly or monthly? Was there evidence, when the post, when the mail person brings the mail, does the dog bark and growl at the mail person? And so by proxy would necessarily, may growl at anyone who approaches the building. All of these things that would go to the question of whether the landlord either did know or should have known that the dog would be inclined to bite somebody if it got out and got onto the common area of a property that is there for the common enjoyment of the tenants. And that's the I think the important thing is, we talk about so often we talk about, well, I have a right to have a dog, or the landlord is inclined to let somebody have a dog, and that's fine. But other people have the right to use the premises, use the yard, they have the right to park the car, they have the right to use their back steps to get up to their apartment. And if there's evidence that a particular dog or any particular pet on a property is vicious, or has a potential, a propensity to engage in some kind of behavior that's violent, then yes, that's why we have liability for those things, and so those are some of the things they should be looking for.
Well, Matt, thank you so much for your time this morning. I really appreciate it. And if folks want to find you, we'll post a link to your profile in the comments section, and they can reach out to you, or any lawyers who are listening to this. A lot of lawyers listen to our podcast and our content. They can reach out to you as well if they're looking to handle or have questions about handling dog bite cases in particular against third parties. So Matt,
there's one last thing I would like to point out, Ryan, though, is that this particular decision is extremely well written. And so I do think that for other attorneys out there, it has rather clear language that is helpful. It's a very well written opinion. And so for that reason, if nothing else, it's quite useful.
Great. And Matt, I will put the site to the case in the comment section. So if anybody is looking for the site to the case, you can check it out. And it makes I think it makes appellate judges' jobs very a lot easier when they have good attorneys who are handling the case. So thank you, Matt.
Thank you, Ryan.